Welcome to another week of Available Work. We're going to get right into it. It's attorney topic day today. But as we discussed earlier with Elsa, we were talking about a claimant filing based on being fired, and now we're going to do the flip side of the coin. If somebody is a quit and also sends claims, does that happen a lot? I mean, I quit from a place of my work, but then I want to say I'm owed benefits.
It does happen a lot, Commissioner, and it's a good question, or it's a good point that you raise about workers who quit and file unemployment claims, because a lot of employers think that if a worker quits, hey, they're done. Mm-hmm. They don't have any entitlement to benefits whatsoever. It's like, hey, they quit the job. But that's not always the case. A lot of workers who quit their jobs will file unemployment claims, and a lot of them win. And this topic is about what can the employer do if they anticipate that somebody's going to file an unemployment claim when they've resigned from their position. And you heard Elsa earlier talking about some elements that are important for the employers to consider when dealing with unemployment claims where the employer was the one to say, hey, look, you can't work here anymore. In these voluntary quit cases, it's like the claimant saying, hey, I'm not going to work here anymore, and they leave. So what's helpful for an employer with these types of claims, you kind of have the three elements, with quit cases. And the first element is it would be helpful if the employer could show that the worker quit the job voluntarily while work was still available to them.
Okay.
That's
the turn right there. Is work still available?
Was work still available? Correct.
I would highlight that if you were reading the employment handbook.
Right. That's important. The second element would be that if the employer could show that the reason that the worker quit was for some non-work related personal reason, not related to the work at all. That would be helpful as well. And if the worker did quit because of some work-related reason, if the employer could show that a reasonable employee would not have quit under those circumstances. And the third element, if applicable, would be if the employer could show that the worker quit before allowing the employer to address whatever alleged complaints the worker might have had to use as their justification for quitting the job while work was still available to them. If the employer can shore up on those three things in a quit case for unemployment claims, I think the employer will be in a good spot, for those claims.
So if there's a distraction, if I'm okay, Elsa's company that sells widgets. If I'm selling widgets and there's a distraction that continues to happen and I'm not able to hit my number that I know I'm supposed to be able to make, but it's because of something that I feel the employer can control, and can I quit because of that? Is that and claim benefits?
Right. So under those circumstances, if the worker is distracted or something like that, from the worker's perspective, if they were to quit the job and file for unemployment, I think one of the things that might get looked at, and I have to say, I can't really guarantee what would happen on an unemployment claim, but with that mentioned, if the worker does quit the job and says, hey, look, TWC, I quit because I was distracted at work, I think one of the things that might get asked of the claimant is, okay, well, did you let the employer know about it?
There you go.
Did you let the employer know?
Give the employer the opportunity to fix it.
Absolutely. Mm-hmm. Yeah. And, as Jiku just had mentioned right there, that's an important element because the worker, at least how these unemployment claims get analyzed when the worker quits, a lot is focused on, hey, if the worker quit, did they allow the employer to remedy their concerns? And so if the worker does not provide the employer an opportunity to do that, that's a hurdle that they would have to overcome, on the unemployment claim, because they're having to show that they had good cause connected with the work for quitting their job. And so if they don't allow the employer an opportunity to remedy in a majority of circumstances, that could, work against them on the unemployment claim. Now, there are some things that hey, look, the worker might not need to approach the employer first, before quitting the job. Some really serious stuff.
Yeah.
Stuff like the employer not paying the worker, for work being done. But some of those extreme circumstances.
Mario, from an employer standpoint, what are some indicators that an employee's voluntary resignation could lead to this unemployment claim?
Very good.
Kind of some red flags or something they can see coming.
Yeah. So I would say this, and I don't think Elsa would contest me saying this for her topic too. But one of the main recurring themes that I think you'll see in these talks today is document. Have things in writing. If a worker approaches you about complaints at the workplace, the employer should tackle those pretty quickly and document that they've done so, such that if the worker does quit because of those things that they've complained about, if the employer has done their due diligence and addressed those things, that's something that they could provide during the unemployment claim. That might in some circumstances tip off the employer to be like, this worker might consider leaving the job, perhaps. Another thing that sometimes you see in unemployment claims, and I'm glad you brought this up in a question, is that sometimes workers will be like, hey, boss, I'm starting to look for a new job. Hey, boss, I'm starting to look for new work or what have you. The employer should be careful not to turn that into a discharge. Because some employers think to themselves, hey, the workers told me that they're looking for new job prospects, they're applying for new jobs. I accept your resignation, or whatever.
So is that an agreement between somebody who's saying I'm going to be leaving, but is it 2 weeks notice? Are they covered by 2 weeks? There's not a rule that gives you 2 weeks, right?
Interesting question, Commissioner. So there's not a hard and fast law that says a worker must provide a 2 weeks notice, but the amount of notice that a worker gives you that they're going to resign by a definite date in the future, which is different than a worker saying, hey, look, I'm thinking about quit. I'm looking for new jobs and so on. Your example is if the worker gives a definitive date that they are going to resign. The amount of notice could be important because if the worker provides a notice to resign by a definitive date that is 2 weeks or less in the future and the employer accepts it at their convenience, the worker will likely be viewed as having quit the job on the unemployment claim if they go file one. If more than 2 weeks notice is given that they're going to resign at a definite, date in the future, that's more than 2 weeks in the future, and the employer accepts it immediately, that will be viewed likely as a discharge on the unemployment claim, with the employer having to prove up all that stuff that Elsa was talking about and the misconduct stuff, because the employer will have initiated the job separation there. So
if you'll remember, we talked with Elsa was benefits on somebody who had been fired.
Correct.
Right. And Jakku, let me bring you into this because this is kind of the in betweeny topic here that we're talking about. What happens when an employer gives a person the option to resign instead of getting fired?
Excellent question, Commissioner. Resignation in lieu of discharge. Now, in those kind of situations, the employer or the employee is kind of being voluntold that you have to resign. Now, in those cases, the commission is very likely to find that it was in fact a discharge rather than a quit.
Okay.
Because at the end of the day, the employer is kind of making that decision for the employee.
Yeah.
So,
So it's mostly being forced.
You're kind of being
you're leaving either out the door or through the window, right?
Exactly. So it's not going to be seen as a resignation from the employees' end because they're being told, you know what, you can resign. Maybe that's for a rehire purposes later down the line. But in those kind of circumstances, if it's a resignation in lieu of discharge, as far as the commission is concerned, it's very likely going to be a discharge from the employer.
So employers should want to know that if you're trying to part ways amicably, you're still gonna you're still gonna eat it at the end.
Well, no,
Or you could.
It really just depends on who's the first one to broach that topic, Commissioner,
okay.
because, things like, hey, we were, we wanted the claimant's resignation, hey, and so on and so forth, especially with the scenario that you had just mentioned right now where it's a resignation in lieu of discharge. That kind of takes the whole thing about work still available for the worker out of the equation. There's really no work available. There's no really further work available because if the worker doesn't resign, they're going to be fired anyway. So that kind of cuts against a huge element that an employer would need to show that continued work was still available and the work left and the claimant left voluntarily.
What about the employee that just leaves? No warning. Just the next day they don't show up.
Just vanish.
Just vanish.
That happens. That happens.
Ghost.
And we've talked about that in some of our meetings there amongst the attorneys in the office, and that's the thing. Since the worker initiates the job separation in these quit cases, sometimes they just deuces. I'm out. And they leave. And I would say to that, hopefully there was somebody else in the room to hear that when it happened. And hopefully you have someone who can put down a statement. Maybe there's video footage of that happening. But if the worker just leaves automatically and, hey, I'm out or what have you, and then they file an unemployment claim, it's like, I was fired or what have you.
Yes.
That would be a evidence issue at that point, because one party is going to say, hey, they quit. And the other one's going to say, well, I was fired. And so it'll be a credibility assessment at that point. Yeah.
So is it once the person doesn't show up, if somebody calls no calls or does a no call, no show, and the employer just decides, okay, we're not expecting this person to be here, do you just write up a statement and have a manager or somebody
that's a really good point. And generally
put that
speaking,
in the file?
Yeah, absolutely. Put that in the
wait for
file.
a claim?
Yeah, laminate it. hang it up on the wall. No, but there is kind of a rule, a rule kind of ish, about these unemployment claims with no call, no shows. Typically, 3 consecutive days of no call, no show where the worker is scheduled for work. If they don't show up for 3 days and it's just completely no call, no show, that will generally be viewed as job abandonment on the unemployment claim, such that the worker would have to show good cause connected with the work for quitting in order to get their benefits. Now, even though they would have to show that they had good cause, realistically, the employer should be prepared to rebut whatever alleged justifications the worker has for quitting their job, kind of thing. Yeah.
And once somebody quits or is fired, what's that lead time afterwards before somebody receives that first notice? Should the employer start getting their ducks in a row, or do they have a year?
Yeah.
What is the time lead on, or the time frame on that?
And really, and Jiku, you can jump in on this one. I mean, it kind of just depends on, when the worker files their claim. That's the key.
Exactly. That's absolutely true, Mario. There's not an exact time frame for them to file a claim, right? It really depends on beforehand. That's like you said, Bonnie. Did the employer get their ducks in a row? Did they do proper documentation? If it was 3 days, if it was the case where it is job abandonment, did the employer make enough documentation to show that they didn't show up for their shift, whatever days it may be? Is there time cards that they have? So it is proper documentation on their end beforehand to prepare for what is to come later down the line as far as how to respond to that claim in question.
Yeah, the claimant could file the day that they get fired. They could file 2 weeks later after that. I won't go into the nitty-gritty specifics of the base period, but basically as long as they have, the proper requirements on that, they can file kind of quite a ways down the line. And so
years down the line?
Not years.
Okay, what's the cutoff there?
Limit, right?
Yeah, that kind of goes, again, I guess the technical answer would be that the claimant would need to file such that they have at least 2 calendar quarters in their base period with base period wages reported for them. It's very technical, but
hoping for an easier answer than that.
That's what I was letting Mario handle.
He's got the rule book in front of him, but he was
Can
not
you write
reading
that one
it.
down for me?
In essence, it could be calendar quarters down the line kind of thing. It could technically be. Now, if you want to get really technical, they could file whenever, but if they don't have those wages in the base period, that they could get disqualified, or the claim could be held invalid rather.
This is for either of y'all, what are some best practices for employers in terms of these employee resignations? Exit interviews or other ways to document why the employee left? Any other?
I'll let Jiku get on this one, but I would just say right off the bat, if a worker brings complaints to you at the workplace, don't blow them off. Make sure that you address those complaints, those grievances. That's something that the employer can do in terms of employee resignations and so on. So I would say definitely investigate any kind of complaints workers bring to you, because if the workers' complaints are not handled or taken seriously, that could provide the worker, hey, look, I've tried, I'm not getting anything here, so maybe I'll quit my job kind of thing.
Yeah. I'm interested in the exit interview. If an employer has one thing to accomplish during that, what is it?
So the main thing is you need to make sure that you build a picture as far as you try to work with this employee. Prior to them quitting their job, you did everything that you could. So in that exit interview, you need to show that, as an employer, you did everything from your end as far as trying to figure out whatever that employee's issues were, whatever their complaints were. You did everything to investigate as an employer to make sure that, whatever their concerns, whatever their comments may be, that they had an issue with the company, you did everything to mitigate that. So if you do that, then you're kind of projecting for the future to show that, you did everything from your end. As an employer, you had all your I's dotted, all your T's crossed, as far as, trying to help this employee to do their job prior to them, turning around and quitting.
Yep. Okay, and try to remember to get their access badge too at that point. Yeah. Kind of stuff like that.
And dot the lowercase j's.
Yeah,
that's right.
That'll be good. So when it comes to folks voluntary leaving, we talked about resignation in lieu of being fired. Mario, what else? Anything else that you want to tie in on the topic?
Yeah, I would just say at the end of the day, because sometimes employers will feel betrayed when a worker tells them that they're looking for other jobs and so on. Be careful about treating that as a resignation on the worker's part, because if the worker is not telling you that they're quitting their job, they're just like looking for other work, or they're considering quitting or what have you. Yeah. That's not the same as saying, I've quit my job. And so if the employer feels like, hey, if I just say I'm accepting your resignation, it'll be a quit on the unemployment claim. That's not always going to be the case, because if the worker has not clearly stated that they are quitting their job, the employer just treats it as such. The employer could be in line for showing misconduct as a way to disqualify the claim from benefits, because it'll look like the employer has fired that worker essentially. So another take-home point, and the last take-home point that I'll say for employers who are thinking about resignations, is that sometimes these quits can be the result of some pay cuts or demotions that the employer initiates to the employee. And that's a concept referred to as a material change in the hiring agreement. So one of the classic examples, a dramatic example, but one to kind of drive home the point, is, say, for instance, you hire a worker to be the CFO of your company, and then later you demote the worker to be the janitor. That could be a circumstance in which the claimant could show that they had good cause connected with the work for quitting. So just as a take-home point, material change that's to the detriment of the worker, and that could include certain types of pay cuts, certain types of demotions, certain types of reductions of hours. So if you want to learn more about that, if you're listening out there in Radioland, you can call our office or visit the Texas Guidebook for Employers online, because the book is also online. You can search for the topic about that and learn more about it.
Mario, thanks for wrapping up.
My pleasure. It was great being here.
That's been wonderful.